Let me cover Social Security numbers, because this is a bone of contention. And we have a lot of programs where we have to use Social Security numbers. Section 7 of the Privacy Act provides that it's unlawful to deny any individual a benefit or privilege provided by law for refusal to disclose their Social Security account number. That seems to make sense. But what a lot of people forget, and I'm even too young to remember this, when the Social Security Act was first passed back in 1935, the Social Security Administration did not consider Social Security numbers to be private. In fact, the Social Security Administration would sell the list of Social Security numbers like people today sell mailing lists or phone lists. So they weren't intended originally to be private. But we use Social Security numbers for a lot more than it was ever intended to be used back then, and there's a lot more security risk in the use of those numbers today. The question comes, this is a federal statute, this is a federal privacy statute, and it deals with federal, state, and local governments, but as with FERPA, there are exceptions. The Privacy Act does not apply to any disclosure which is required by federal statute. Now, for the Access Program, for ELECT, Upward Bound, Talent Search, whatever program you're talking about, guess what? Many of those programs require the use of Social Security numbers. And guess what? The exception swallows the rule. We can require the disclosure of Social Security numbers for the use in those programs for which the federal government requires us to use those. So what we have to be careful of is the privacy and confidentiality of those numbers. The federal government has identified and given us some guidance on this. The routine use of Social Security numbers exposes students to increased risk of identity theft, and they really like to get student numbers because they can open credit cards with them. The Social Security Administration has recommended that school entities not use Social Security numbers for identifiers. They recommend that educational institutions do use alternative numbers, which we have to be careful. Remember that linkable word I used earlier? We have to make sure that they're not linkable back. And again, the agency that protects education records under FERPA, the Family Policy Compliance Office, considers Social Security numbers to be high risk, and they place a greater burden on us to protect against theft of those numbers. And of course, they do consider those to be personally identifiable information that require consent to be disclosed. There are exceptions to FERPA. If you go back a number of slides now to the FERPA exceptions that I gave you, you'll find a couple of them that apply here. One is the disclosure to federal, state, and local officials, and another would be to disclosure to organizations that are conducting studies. But regardless of the exceptions to the Privacy Act, there is an exception in the Privacy Act for the disclosure where required by federal statute. So we're going to continue to use them, but we've got to make sure that we don't inadvertently allow those to be disclosed outside. You don't disclose them to the general public. We stopped using them, I think, as identifiers a while ago. Some people continue to use maybe the last 4 digits as an identifier, and I remember the days when school districts used to post grades, or colleges even posted grades using the last 4 digits of the Social Security number. The administration doesn't want us to do that. In fact, the Family Policy and Compliance Office doesn't, or suggests that you don't even use other student identifiers to publicly post grades because of the linkability. And one of the things that they tell you not to do is to use Social Security numbers to interface with databases, again, back to the electronic records, where they're maintained by third parties that we don't control. So we need to be able to redact information when necessary. A couple of questions that came up during the break that I'll answer very quickly because I think they can be. I was asked to speak about whether you can include clinical evaluations from outside agencies in the ER or RRs. And I go back to the definition of educational record, and that is a record that is related to a student and maintained by an educational agency or institution or agency acting for that agency or institution. And the answer then is, once you receive a clinical evaluation, it's going to become part of the educational record, so that yes, you may include those in your ERs and RRs with appropriate attribution. I was also asked, people are always complaining that lawyers give wishy-washy answers. Do I need a lock from my filing cabinet that holds student records in my classroom? Some student records are held in a central repository. Some may be held in your office. You may have sole possession records that don't meet the definition of educational records. But the short answer is yes, get a lock. Okay? No wishy-washy answer. Also, I should announce for you that all of the things that I'm talking about today are probably going to be followed up with a discussion at the cabinet level, and the intent, I think, is to form a committee in which some of you may be asked or requested to volunteer to participate in, to review IU policies and develop procedures as a follow-up to this discussion. So if you have that interest, you might want that made known to Christy or one of the other members of the cabinet. I think we can all agree to these student data principles, that it's necessary for us to gather student data to help us to provide better education for the students. But it's also clear that we need to safeguard those records once we get them. That's part of the procedures that I think that committee will address. For electronic data security, I actually attended a seminar sponsored by the Council of School Attorneys of the National School Board Association in May, and these are some of the things that they told us. I think it's important to note that Fordham issued this scathing report about the fact that we maintain electronic records of school districts without adequate security. That needs to be addressed. I've been mentioning earlier today about a number of online vendors who are providing educational software and other things that you use in classrooms. Recognizing the implications of privacy and confidentiality concerns, they created this privacy pledge in which they agreed to be bound by FERPA. And then, according to the Electronic Frontier Foundation, they immediately proceeded to breach that pledge. But you can see that data security and third-party access to student records is identified as the #1 issue. The privacy pledge that I mentioned is is in front of you there. There's actually a commitment by the online service providers to be a school official under FERPA. They didn't do that for any altruistic reason. They did it because they wanted to beat the federal regulators to the punch. The query and the thing that I think they overlooked is when they issue a statement like that and say that we're going to be committed to maintaining the privacy and confidentiality of student records in the electronic format, they've probably brought themselves within the jurisdiction of the Federal Trade Commission, so that any breach of that pledge then becomes an unfair trade practice. And that's exactly what we see happening. As of the time I went to the seminar, there were 269 online vendors that signed that pledge. The pledge is not to sell student information, not to behaviorally target advertising. That's the big question and the big issue with regard to accessing student online data. They agree to use the data for authorized educational purposes only. We'll look at that. They agree not to change their privacy policies without notice. Privacy policies itself is a misnomer. We're going to talk about that too. They'll enforce strict limits on data retention, and they're going to be transparent. That's their pledge. Sounds pretty good. I thought it sounded pretty good too, except I'm a lawyer. And so we're going to explore this a little bit. One of the things that they do in these online agreements is identify themselves as a school official. And of course, we can identify, or we can exchange student educational records with school officials that have a legitimate educational interest. Well, these online software vendors certainly have a legitimate educational interest in the students and the online services that they're providing. The United States Department of Education has a privacy technical assistance center, and they actually agree that this is a pretty good idea, and they in fact allow the use of metadata, and some of you who are technologically savvy will know what metadata is, but that's data that identifies or provides information about other data. And we can often look behind that to watch online traffic. If you're familiar with Twitter and what's trending now, they're looking at metadata to find out what's trending now. So the provider, the online vendor, can use non-personally identifiable information such as metadata with all of the identifiers removed to create new products, which is a good thing for education, and to provide school entities then with information that they can market these new products with. But I mentioned the Electronic Frontier Foundation's suit against Google for violation of the pledge. Their claims are that Google collects data and uses personally identifiable information without authorization in violation of the pledge. One of the things they do, if you have Chromebooks, or if the districts in which you operate have Chromebooks, there's a setting in Chromebooks called Chrome Sync. Chrome Sync is set by default in the Chromebook, and that allows Google to access metadata and personally identifiable information on students or end users that they can then use to target ads, to market. That's the complaint. So EFF is saying Google enables the collection and sharing of this personal information because of how they do settings on Chromebooks and other things. So the question is that a deceptive trade practice because it's a violation of the pledge and within the jurisdiction of the Federal Trade Commission? Is it a FERPA violation because they're a school official that's now sharing information without a legitimate educational interest because they've now gone beyond the authorized educational use? Google says, hey, we're doing this all for altruistic reasons. Our goal is to ensure that teachers and students have access to powerful, affordable, and easy-to-use tools for teaching, and we're always committed to keeping the student information private and secure. That's the director of Google Apps for Education. That's the acronym GAFE. Now, that sounds really good until you look behind the agreements. Google Apps for Education agrees in their actual software agreement. If you look on their license agreement, it says in section 104 that it does not serve ads in the services, okay, or use customer data for ad purposes. I capitalized the word services for a reason. They capitalized it. That is a term of art in the agreement. And the term services in the Google Apps for Education agreement means Google Apps for Education core services, Google Classroom, and Google Apps Vault services if they are used. Those are all defined terms. Section 7.4, they acknowledge that that customer data may include personally identifiable information. They're going to be bound by FERPA. So, sounds pretty good. Except you have to read section 2.2, which says that Google will make other non-Google Apps products beyond the services, including, are available to its customer and its end users, read that, students, in accordance with the non-Google Apps terms and the applicable product-specific terms of service. What does that mean? That means you have to go online and find those documents and read them. I did. All right? The services do not include non-Google Apps products, which means that's not subject to what they just said in the last slide. All right? So, what are non-Google Apps products? There's a long list of them if you go online. Let me tell you a couple of them, just a couple. Google Groups, discussion groups, Google Books, Google Photos, Google Maps, Google Chrome Sync, Google News, Google Plus, and YouTube. Now, how many people use any one of those in the classroom? No hands. All right. That is the tip of the non-Google app product iceberg. Okay? If those products are being used in the classroom, they are not subject to the pledge that Google gave you a couple slides ago. And what does that mean? That means they are not committing to not mining student data for targeting ads. If you go to those documents, you read the terms of service, and the end user has the ability to read the privacy policies. Privacy is a misnomer. Let me just tell you that right up front. When the end user, again, read that student, uploads, submits, stores, or sends any content in one of those non-Google app product, they give a worldwide license to Google to use it. Google is also authorized to analyze the content, including emails, Google Plus email accounts, to provide the end user with personally relevant products and product features such as customized searches, tailored advertising, and spam and malware protection. So if, as part of the classroom procedures, because you're using Google products, including the non-Google app products, you set up student Google accounts, Gmail accounts, and the like, Google may not only use that information, but now and this goes back to before the break, Google may display the individual student profile name, photo, and any actions taken. So when we go back to the directory information and the parent ability to opt out, are we inadvertently, and the answer is yes, inadvertently violating FERPA and an opt-out that the parent has elected not to have that available as directory information? So we have to be very careful. I mentioned the Children Online Privacy Protection Act. This requires an operator of a commercial website, read Google in this case, that knowingly collects information targeting children under 13. And in this day and age, how many of the students in the elementary buildings are getting iPads as part of their core curriculum? They must obtain verifiable parental consent, but what they have to do is have a privacy policy. Well, they do. We're going to look at the privacy policy in a minute. The dangerous part for us is that in many cases, not all cases, school districts or school entities may consent for the parents. So we've got to be careful in what we're allowing online vendors to access for our students. Now, this is the situation where parent consent is necessary. If they intend to use or disclose personal information for their own commercial purposes, they have to get the parental consent. Well, the question becomes, do the parents know that they have access to it? Because they've committed in Google Apps for Education that they're only going to use it for legitimate and authorized educational purposes, and then they allow you to use these non-Google Apps products in which they make completely the opposite determination. So we've got to be very careful in what products we're using and and how we use those products. This is the Google privacy policy. It identifies what information they collect and how they use and share it. It's not private, it's how they use and share it. This is their privacy policy, how they use and share. So it advises the end user, the uninitiated student, that when you share information with Google by creating a Google account, it can make services better by showing you more relevant search results and ads to help the individual connect with people and make sharing quicker and easier. Sounds very altruistic. They really aren't private at all. They're telling you how they're going to share, not how they're going to not share, not how they're going to keep it confidential, how they're going to share. This is how we prevent that from happening. The Google privacy policy does state that Google will respect the choices that individuals make in limiting sharing or viewing. You go into your settings in your Google apps and you tell them what you don't want them to share. So you view and edit your preferences in settings in your Google account. Okay? That allows the end user to control the sharing of information. Among the things that you can do are block all cookies, including cookies that are associated with Google services, or advise when a cookie is being sent by Google. Google will tell you that that might cause the services not to function properly. But we've got to look at it as if we're using non-Google app products for our students, we've got to maintain the confidentiality and privacy, and Google has already told us in their agreements that they're really not doing that except for the Google Apps for Education committed products, which are defined. So you need to know which are the Google Apps for Education products and which are not. And then if you're going to use them, you need to make sure that the privacy settings comport with what you need them to say as far as maintaining student privacy. All right. So the Google Apps for Education agreement protects the IU and the student from ads and mining personal data, but only for those services. So to the extent you're using any other services, you're wide open. I'm not picking on Google. 269 vendors signed the pledge. There are 269 different contracts online that have probably multiple different products and multiple terms of service. Those need to be reviewed for privacy concerns. And we need to understand, as we enter the online arena, there are pitfalls to the privacy and confidentiality of student records. Now, the next part we're going to talk about is the pitfall of actually executing an agreement when you didn't think you did that. And the first thing I want to tell you about is the school code. The Pennsylvania Public School Code was adopted in 1949. I wish it had been updated. There are amendments, but 49. Section 508 of the school code says that entering into a contract of any kind, including the purchase of fuel or any supplies, where the amount exceeds $100, requires the vote of a majority of the whole board. In the IU, that's 9 of 17 board members. In local school districts, that's 5 of 9, regardless of the number that actually attend the meeting. So to enter into a valid contract, we need board approval. But we're in the electronic age, and here's the pitfall. Online agreements. You're going to hear a couple terms: browse wrap agreements and click wrap agreements. Browse wrap agreements, you go online, you're looking for a product that will help students one way or another. So you go online and you find a vendor, you find a product that you really, really like, okay? And in order to access that agreement, a browse wrap agreement would tell you, here's a link to our terms of service. Okay? The terms of service aren't on this page. You have to go to another page to read the terms of service. Okay? No hands. How many people read those? Okay. When you pay your bills online and they tell you to authorize to do this, how many people read that before they click the box? How many people read any of the license agreements for the software that you purchase? Okay. So when they offer you a hyperlink to the terms of service, that requires a PhD to read, how many of you are going to go and read it and know what it says? That's a browse wrap agreement. A click wrap agreement is the other version where you can't get to the next page without looking at the terms of service. You have to click the box and you actually have to go to the terms of service before you're allowed to proceed. They're going to assume that you read that. You don't. I know you don't. All right. That's a click wrap agreement because you've actually done an affirmative act to acknowledge that you saw what you didn't really see. Okay? It's a nice trick. Browse wrap agreements generally are not enforceable because they haven't proven the element of assent to the contract. But a click wrap agreement, you take an affirmative act of clicking a box to say, I read and agree to the terms of service that you did not read. And we have the element of assent. So, if you click on a click wrap, you have entered into a valid contract. How many here actually believe that they have the authority to do that? No hands. Now, I've mentioned the enforceability, so we can skip that. Here's what I want you to do. If you're looking at software licenses and you want to use a product, you need to read the license. Maybe you don't. Maybe you need me to read the license. Okay? All right. You need to understand the terms of use and the privacy provisions, because remember, I just showed you the Google privacy policy and it's not private at all. You need to understand that if a student or as an end user is using a product, is that product going to violate their rights under FERPA? So, you got to read it. You got to understand it. You got to avoid clicking through. You probably want to have somebody do that for you in advance and have a pre-approved list of those online services that we're actually going to use. And we're going to have the right people approve those agreements. And then we're also going to train on how to change the settings for privacy purposes so that we don't run afoul of FERPA. Because remember, educational records are not necessarily paper anymore. Once a student is using an online service and creating documents online and saving them online, those electronic records are indeed educational records, and they're subject to FERPA. So, electronic records and privacy concerns. We have moved away from paper, and we've got desktops, and we've got laptops, and we've got tablets, and we've got smartphones, and we got flash drives, and we lose laptops and smartphones and and flash. We lose them. And when we lose them, and they contain electronic records for a student, we have a data breach. How many people access a student record on a tablet or a cell phone? No hands. How many people that have that access have a security code that requires you to put it in before you open the phone or the tablet? And if you don't, and you, oh my God, leave it in Starbucks, then you've just opened all of those apps on your phone or your tablet to anybody that's in Starbucks or takes it from Starbucks, including any accessible student records. So, we need, number one, to protect the portable equipment so that they are useless to somebody that accesses them. We need to be mindful that they contain private information. And we also need to report when we goofed, because we do have data breaches in that case. And we need to control that. So, a couple of things to do. Electronic records transfers. I don't recommend you use Social Security numbers as student identifiers in electronic emails or other communications. Don't use any identifiers that may be linkable to a student. I always recommend that you encrypt. Vince? Always password protect your documents. If you have to and you're delivering it electronically, deliver the document with a separate email with the password information. Don't put the password for the document that you're sending in the transmittal email. All right? Always request a read receipt so that you know that the document was delivered to the person that you intended to send it to. It's very easy in the autofill or autocorrect days to send it to the wrong person inadvertently. I have done that myself. I have a board member whose name is Cheryl, and I have a IU board secretary whose name is Cheryl. And damn autofill sent the document to the wrong person. Right? So it's easy to do. You can actually turn off autofill. So you need to be mindful, and that's why I say take a read receipt so you know it went to the right person. If it went to the wrong person, ask for it back. Ask them to destroy it, but don't let it go. Right? Always use network stations that are protected by our software. Don't go rogue. Don't use wireless communication. Don't use a public computer. And don't use the Wi-Fi at McDonald's. A couple award-winning websites that I'm familiar with. The Social Security Administration has an electronic access that, if I'm representing a claimant in front of the Social Security Administration, I have electronic access to all of that person's information. They require you to go to training and register your cell phone number. And if you want access, you have to give them your representative ID and your user ID, and they will send you a text message to your cell phone, and it's good for 10 minutes. And you put the password in to the website, and that's when you get access. So you have to have all of that information in order to gain access to it. Other websites require you to change your password very frequently. I kind of like the idea of individual passwords, but I know that that's not practical in a lot of situations. So let's talk about data breaches. If there's an unauthorized release of information, a lot of times it's our fault. Hackers, not so much. I mean, if you look at the studies, they'll tell you 95% of data breaches are human error. Okay, so that's the lost or stolen or the temporarily misplaced equipment. That's the employee negligence. That's our policy or system failure, but it's not a hacker. 95% of the time. So when we lose those flash drives, when we leave our tablets unsecured, open, and we leave them behind, we've got a problem. This is what I recommend you do before a data breach. Number one is to establish a policy for how you will respond to breaches. And it's a checklist. I actually have one for Vince already, so we'll work through that. Review your information systems to make sure that they're adequately protected. And I know Vince and I have talked about this, conducting regular risk assessments. We separate security much like we do in the financial area so that there is a series of checks and balances. Mitigation controls. Keep our data, our student record destruction policies up to date and monitor that. As I mentioned, our policy says we're going to keep records for 6 years. If we have them for 7, we're not following our policy. So there's access to records that we maybe under our policies shouldn't even have. So we've got to be careful about that. In the event of a data breach, FERPA doesn't require us to tell anybody. Isn't that amazing? The statute that says that we've got to be careful in how we disseminate information and controlling all that doesn't say that when a student's records are accessed that we have to tell the parent. I think they're going to correct that because FERPA was written actually before electronic records became vogue, but what we have to do, and I mentioned this in the first part, we've got to log the breach. Remember I said we've got to keep a log of anybody who's accessed the record, the date, who accesses, the purpose of the record. So we're going to go into the log and say, hey, I had a data breach, occurred on this date, this is what happened, somebody left their laptop in Panera, and we don't know if anybody accessed it or not. Maybe they did. We got a log that a breach occurred because we don't know what happened. Okay. We have to understand what federal, state, or local laws apply. We know FERPA applies. If we're working with the Health Information Technology and Economic and Clinical Health Act, which we may be for some of our federal programs, they actually require us to tell them if there's been a data breach. So for some of our programs where we have students with health diagnosis, that may actually happen. So what do we do in the case of a breach? First of all, make sure it happened. Okay. Second, we should have somebody in our IT department manage that and assemble a team to determine how broad that is. If we have someone that's hacked into our system and has access to everything, or did we lose a flash drive with a student IEP on it? So what's the scope? Interview all those people that were involved, preserve the evidence. I recommend here that we notify the owners for several reasons. One, they're going to find out anyway, and even though FERPA doesn't require us to tell them that, that's good public relations when you're talking about student records, is that you tell them that, oops, because you don't want them to find out from somebody else. You might consider notifying the Family Policy Compliance Office. The Department of Ed does consider that to be a best practice, but that's not currently required. So that it's easy to have that happen. I'm carrying at least 2 flash drives in my pocket right now. So I could lose those in an instant, and you can too. It's very easy to leave stuff behind, especially when you're carrying a lot of stuff around. So be mindful of that. Make sure that those things are protected. Okay. Different topic. How am I doing? It's 11 o'clock. Do you want me to go here? We're okay? Okay. Wanted to cover a couple things. We all know, and I'll cover these rather fast. We all know that school employees are a mandatory reporter. I'm a mandatory reporter these days. We do have, and you should be familiar with IU Policy 806 on child abuse. The definition comes right from the Act, so be mindful of that. A couple of things I wanted to point out under number 8, engaging in any of the following. It's unreasonable restraining or confining a child. A lot of us are trained in handle with care. We're not talking about that. We're talking about unreasonable restraint and persons that aren't restrained. We all know that we're not supposed to do prone restraints that may possibly interfere with the breathing of a child. But if you're trained and if you're exercising that in accordance with our policies, then you're not going to be subject to number 8. But if you're not trained and if you're doing it in a moment of frustration and anger, you might be. I wanted to cover this one. This is the definition of sexual abuse or exploitation, and this comes from Act 120 of 2012, and it's part of the Professional Educator Discipline Act. And the reason I wanted to highlight this is sexual abuse or sexual exploitation, the definition has changed, and the definition has expanded. And now it means not only actual sexual abuse, sexual relation, but it also talks about grooming activities, precursor activities that may lead to something down the road. We've had a number of situations here locally and nationally about that. I think we just need to be very careful about how we interact with students. Among the things that the Standards and Practices Commission thinks are grooming activities, and they take a very broad view of grooming, but it's I want to read it for you. An inappropriate relationship between the teacher and the student is usually the result of prolonged process of gaining trust, blurring boundaries, and desensitization. Common grooming behaviors include taking an undue interest in a student, giving gifts or special privileges to the student, getting the student out of class repeatedly to visit the teacher, or inviting the student to come to the classroom at non-class times, being alone with the student in private spaces, complimenting the student's appearance or body, engaging in peer-like behaviors with the student, talking to the student about matters that would normally be discussed with adults, marital or personal problems, sexual experiences, telling students secrets and having secrets with the student, contact with the student beyond the school day, using email, text messaging, or websites to discuss personal topics or interests with students, engaging in talk containing sexual innuendo or banter with students, telling sexually explicit jokes, or hugging, kissing, or other physical contact with the student. We need to be aware of that because in our Act 126, they amended, I'm going to forget the statute now, I guess. I think it's the school code, of course. They amended and made it a requirement for all our staff to be trained in child abuse. Item number 4 in the training, the topic must include maintenance of professional and appropriate relationships with students. So once we get beyond that, I think we start the slippery slope. Because of time, I'm going to skip the child line investigation, other than the fact that I'll highlight there. We have a duty to cooperate. Remember when I said things about obtaining subpoenas for records? They don't need subpoenas. They come in and they say, give me your records. They come in and they say, I want to interview this student. Your answer is not, well, he has lunch at, or he has a study hall at. No. Get him out of class now. Well, I have to call the parent. No, you don't. Okay? You have a duty to cooperate. So I will tell you that. You can read these on the slides. I wanted you to be aware of Policy 824, which is a new IU policy, and this is on maintaining professional adult-student boundaries. You should be familiar with that because it does, in fact, address grooming behaviors. I have a couple of slides here, and I know I'm going through these rather quickly. Go through this list in your own mind's eye, and I'm going to tell you, I've been practicing law for 34 years. I have had every one of these in my experience. Every one of these. This is not unusual. I've also had every one of these in my experience. And every one of those. We've got to be careful and I say this all the time, in the post-Jerry Sandusky era, we do not have the luxury of waiting for something untoward to happen. We've got to nip it in the bud early. So, and the amazing thing is, and I'm talking about electronic records today, most of my cases are proven through electronic records. How many people think that when they delete a conversation on Facebook, it's gone? No hands, because it's not. I have in my possession hundreds of pages of deleted documents that I will use to pull certificates and dismiss employees, and they think that it's gone. It is not gone. If you put it on the internet, it is there forever. It may be under millions of other documents, but it's findable. And a forensic review of a computer, a forensic review of a cell phone, I can get anything, literally, and have. So, fair warning, don't let that happen. There are many cases in which students may need some intervention. And I'm not saying that you shouldn't be a good teacher, but know the boundaries. If you're, providing other related services, that there are things that you can do. Among the things you can do to protect yourself is to report the student needs to a student assistance program team or somebody else. Don't go it alone, because even if you have the best of intentions, in the post-Jerry Sandusky age, we've got to view you as having the worst of motives. And if you're going it alone and nobody knows what you're doing, that's when you're going to get in trouble. That's what the policy is designed to prevent. And I think you should take that to heart. And if I can, I think I'll leave you with that. I will say, I gave an in-service presentation to another school district in February about social media. That was the only topic I talked about for about an hour and a half. And my intent was to make everyone aware of the danger. And the superintendent told me, you had those people scared to death. Okay, that's probably a good thing. He told me several teachers unfriended students before I was done talking. You bet it. You bet. There's a couple things that you have to remember. If you friended a student, kind of ask yourself why, first of all, okay? We'll just use Facebook as an example. Why are you friends with a student on Facebook? But let's go beyond that. If you're a friend with a student on Facebook, what does the student have access to on your Facebook account? What pictures do you have that the student has access to? The bachelorette party? New Year's Eve? Think about maintaining professional and appropriate relationships and whether that dovetails with friending students. Thanks very much.